All rise. Hear ye, hear ye. Court of Appeals for the First District of Texas is now in session. Pursuant to the United States Constitution and this honorable court.
Please be seated. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is 0123-00158 CV, Mark Allen Swanson versus Robert Danny CLACK. Starting with appellant, counsel, please make your announcements.
BEVERLY for appellant and cross APPELLEE, Mark Swanson.
For appellee?
NITIN sued on behalf of APPELLEE and cross appellant Danny CLACK.
Okay, very well. Each side is going to have 20 minutes for argument. Does appellant wish to reserve any time for rebuttal?
Three minutes, Your Honor.
Okay, appellant wishes to reserve 3 minutes for rebuttal. And before we begin, just some housekeeping matters. This is basic to you all, but you see the lights here in the front. The light will turn yellow when you have 1 minute left. And then of course, red means stop. If you have a question pending, please go ahead and continue your answer. We do not need a full recitation of the facts. We have read the briefs at length. We're familiar with the facts and the record in this case. It would be most helpful to us if you can dive right into the legal issues, especially with the time constraints. We're ready to proceed and to hear from the appellant. Mr. BEVERLY, given the issues, I would ask you to start off, please, with your argument addressing issues 1 and 2 in your appeal, addressing the legal and factual sufficiency of the award on the issue of conversion.
Yes, Your Honor. With respect to the sufficiency of the evidence on damages for conversion, what we have here is basically the bare bones testimony of Mr. CLACK. There were no expert opinion, no exhibits, no real explanation of how the particular property was valued. And if you look in Appendix 11 of our brief, which I'm sure you have, you'll see where we detail that evidence. Now, to overcome that, Mr. CLACK has to rely on the decision in Burns v. Roshan out of this court in 2006, basically holding that a property owner's testimony doesn't have to meet any real standards. First, I'm going to say I have the greatest respect for former Justice Kise. I thought she was a great judge. She was always committed to doing the right thing, but I think the Burns decision flies in the face of authority from the Texas Supreme Court, including the later decision in National Gas Pipeline v. Justice. And that case clearly sets out the standards for property owner testimony, that it must meet the standards for any other opinion testimony, and that it's the basis of the opinion that counts, not necessarily that the property owner is testifying.
Mr. BEVERLY, if we agree with you that justice is the standard that we're supposed to follow here, and that we're supposed to look at evidence of fair market value, do you concede that there was at least some evidence of fair market value to some of the items that were listed under jury question number 1?
No, Your Honor, we do not.
So your position is that as to all items listed under question number 1, the evidence was legally insufficient under the fair market value standard in justice?
Yes, Your Honor. Also, in addition to justice, we have to look at Rule of Evidence 701, which the primary requirement there is that it's rationally based on the witness's perception. Now, the property owner rule itself, as you're aware, is designed to relieve the property owner from the burden of qualification. But nonetheless, that testimony can't just be based on naked speculation or guesswork. Now, there's a lot of detail in justice about how that should apply, so I would refer the court to that opinion specifically.
Would Mr. CLACK's testimony alone, having gone further than a purchase price, for example, have sufficed under justice? Or is your position that there had to be some sort of expert testimony supporting the value of the items? Not
expert testimony, but some testimony regarding how he reached the issue of valuation for each piece of particular property. And there's really nowhere in the evidence. There is some evidence of purchase price, but if you'll look at the cases that we've cited, particularly Watke and Murray, Watke v. Yolton specifically, which basically says purchase price is no particular evidence of value. It may be a starting point, but you have to go through and look at numerous factors. It holds that cost alone would not be the correct criterion for present value. You have to consider present condition, wear, depreciation, use, and whether the items are out of date.
Is it your position that fair market value was the measure of damages submitted to the jury? Was there a definition on fair market value?
There was no definition on fair market value. It's not in the jury charge. It's the, can't remember the exact phrase of the jury charge, but I think it reasonably equates to fair market value.
I believe it's what money, if any, if paid now in cash, would fairly and reasonably compensate Mr. Clack. Based on the Osterberg versus Peka line of cases, don't we measure sufficiency just based on the definition given?
Well, I think the definition's not perfect, but I do think it basically equates to fair market value. It does talk about the fair value to Mr. Clack. So I think we can look at fair market value, and that obviously is the supposed standard for a conversion case. So,
counsel,
yes, sir.
The Burns case says that when it's unclear whether or not the court used fair market value, then, and where the owner's testimony was not controverted, then that's when the owner's testimony is sufficient. It seems like there may be a way to harmonize that in the justice case, because here we also have some ambiguity whether fairly and reasonably is really fair market value. What do you say to that?
Well, I think the Burns case is really out of step, because if you look at the cases that Burns relies on, especially the San Antonio Public Service v. Murray, that case only says that the owner's testimony is admissible. It doesn't deal with the probative value of whether that testimony is sufficient. If you look at the Watke versus Yolton case, as I just discussed, it says, as I noted, cost alone is not the correct criteria. It goes through all the factors. The thing that Burns really, I think, gets wrong is when it talks about the testimony is sufficient even if it's halting and indefinite, which I think that certainly meets the standard. That certainly is what Mr. Clack's testimony was. It was halting and indefinite. But if you look at where
Mr.
Burns...
Beverly, before you move on from that, just to help us walk through this, because if we ultimately agree with you, but we conclude that there is legally or factually sufficient under the standard that you're articulating under justice for at least some of the items, can you help us understand, in your view, because there's almost like 50 or 60 items here,
Right.
if we find that there is some legally sufficient evidence under the standard that you're articulating, is your position that we would have to reverse the entire damage award, or would we do a suggestion of remiture?
I think I would ask for a reversal of the entire damage award based kind of under the Castile framework, where we don't know exactly where the ultimate value of around $50,000 came from. So we don't particularly know. So we would have a difficulty saying, okay, this was okay, this was not. So we would have
But there is no
difficulty there.
objection to the jury charge.
Correct.
And so is it your position that you, to the extent that this was a Castile problem, was it preserved below?
I think it was preserved by our motion for JNOV and our motion for new trial.
And what was the argument there that would have preserved that issue?
The argument there was that there was insufficient evidence, factually and legally insufficient evidence to support the charge to begin with.
Say that we find or determine that 5 of the 50 damage is awarded or legally insufficient evidence, and we get rid of those. Why wouldn't we just modify the judgment down based on those amounts?
That could be a possible remedy. Leave it up to the court to make the decision on that. But I think when you look at the evidence, I don't think there is sufficient evidence on any of the items. So I would not support that as a possible remedy on appeal. I did want to talk about this halting or indefinite testimony. I've traced it back, and it goes all the way back to a case, Fort Worth case, 1925, Hartford Fire v. Owens, and if you look at that case, it was an insurance case where a car was damaged, and the Fort Worth Court of Appeals basically said that the owner's valuation in an insurance case is okay even if given in a halting or rather indefinite manner. And that comment seems to me to be more directed at the way the testimony was given and the actual substance of the testimony. And if you look at the facts, it was a difference between $1,500 for the car and $800 for maximum insurance value. So I think the court just kind of discounted that and gave it to the plaintiff on that one.
Mr. Beverly, can you transition to issue 2 on causation?
Yes.
The specific argument in jury question number 1, although there was not a specific question that was presented to the jury on causation, it seems that jury question number 1 incorporated some aspect of causation in the way that it was written. Would you agree with that?
I hadn't really considered that, Your Honor. I don't think that is the case. I think the elements of conversion are actually set forth in question number 3.
Can I read you question number 1 so
Sure.
that you know specifically the language that I'm looking at? It says, what sum of money, if any, if paid now in cash, would fairly and reasonably compensate Mr. Clark for his damages, and this is the part, that resulted from the loss of his property for each of the following items? So the way I'm reading it is that there's a causation component in question jury number 1.
I don't read it that same way, Your Honor. The loss of the property is a kind of a given, basically, in a conversion claim. If you look at question number 3, it does set out the elements, actual elements of conversion. So I think that's the question we have to look at with respect to whether there was sufficient evidence of actual conversion of the property. And when we look at that, I did want to get to that. In the jury charge, as we have argued, we don't think that question number 3 actually supports a finding of conversion of the property in question number 1. It just says, did he convert any of the property? That is completely nonspecific and does not tie it back to question number 1. It would have been very easy for them to submit a charge and just said, did he convert the property in question number 1, either globally or give a list.
Isn't that a Castile type error that should have been preserved?
No, I don't think so. I think that's basically just an improper question that doesn't get to the actual facts of a claim for conversion.
Counsel, did Mr. Swanson object to this charge at trial?
There was no objection to the charge.
Okay.
So,
Yeah, because there is no predicate language for question number 3. I understand that your argument is that we can't really tie it back to number 1. I agree with you. There's something unusual about the jury questions. It seems to me that number 3 probably should have come before number 1. But because the jury in question number 1 did specifically find value for a whole host of items, when the jury was asked then in question number 3 whether any of those items have been converted, isn't it sufficient for us to determine that that was a finding on any of these listed items under question number 1?
if question number 3 had actually asked that, I would agree. But question number 3 does not. It just says, did he convert any of Mr. Clack's property, not any of the property in question number 1.
Yeah, fair enough. That language, I agree with you, is not there.
Mm-hmm.
So would you agree then, based on that question, we don't know, the jury could have found that all these items were converted, none of them, one of them, we don't know, right?
We don't know, and if you'll note, there's several items in question number 1 that have no value, that there's no value associated with it. If it's those items, then there are no damages. In any event, I did want to talk about kind of the lack of evidence of conversion itself. As far as when we challenge, that there's no evidence of the conversion itself, Mr. Clack points to several things. We first note that, there's no witness, there's no exhibit, and there's actually no evidence whatsoever that Mr. Swanson removed any of the personal property that's listed in question number 1.
It seems to me that that's a question as to whether there's direct evidence of conversion. Why is the circumstantial evidence here that was presented not sufficient to uphold that finding by the jury.
I don't think the circumstantial evidence gets you there. The circumstantial evidence is that he was present on the property. Mr. Swanson specifically denied removing any property from that. He did talk about the little bit of property that he did remove, which was some garbage and items of no value that aren't listed in question.
Well, he denied it, but that would be a credibility assessment that the jury had to make.
I agree, but there's no one that came in and testified that Mr. Swanson actually removed any of these properties.
Is there any evidence that anyone else had access to the house besides Mr. Swanson, Mr. Clack?
I haven't seen that. I don't think there's anything in the record. As close as you get on circumstantial was the evidence that of the Ring camera footage, that there was Mr. Swanson was there and there was a trailer, that his truck was backed up in the driveway. Now, if there was Ring camera footage of him actually hauling away something, I would say yes, then we have some real evidence. But just the fact that he is there, he thinks the property is abandoned, legitimately, I think, because it's undisputed testimony that there were no utilities turned on and that the neighbors had told him they hadn't seen Mr. Clack in months.
Is it not enough that Mr. Clack testified he had these items? The only person who would have had access to the house is either himself or Mr. Swanson. And that while he was moving, we know there's some video footage that shows that Mr. Swanson was on the property, presumably without authority to be there. And then these items are gone. The jury could have connected the dots based on that evidence.
I don't really see how that gets you there. Really, we don't have anyone, as far as circumstantial evidence goes, we don't have anyone actually testifying regarding what was actually removed. We have Mr. Clack's testimony that this property was there. We have Mr. Swanson's testimony that he didn't remove anything. So I'm not really sure how we get there on the circumstantial evidence basis. Yes, Your Honor.
Counsel, you've mentioned that there's no objection to the jury charge. So under Texas Rule of Civil Procedure 279, if an element's missing and there's no objection, then the omitted element can be deemed found by the court in a manner to support the judgment. How do you get around that situation?
Well, the elements of conversion are there in the question.
Okay.
So that was not
You feel like the
really an
elements
issue.
are there.
Yeah.
You just feel like the evidence is not there.
Yeah, it's just the evidence that we're challenging there.
Mm-hmm.
And I think it was Mr. Clack's burden to submit a correct question. We're not obligated to help him submit a correct question on matters that he has the burden of proof on. So if the question, I'm not feeling bad, but I'm not going to help someone out if they can't get a jury charge correct, and it's not my burden.
Right.
So.
Can you transition to segregation of attorney's fees? Was that issue raised by Mr. Swanson below, and was that properly preserved?
It's raised in our, again, it's raised in our motion for new trial and our motion for JNOB, which you can preserve that issue as far as legal and factual sufficiency of the evidence.
Okay, that was my question. Is it sufficient that they raised it in the motion for new trial?
Yes, I believe that is. And if, don't have time to go through it, but if you actually look through the testimony and the evidence, in fact, Mr. Jaffe, Mr. Clack's attorney, testified that basically he couldn't separate a lot of this out because he thought it was all tied together. But if you actually look at the evidence of what he was doing, clearly he was doing a lot more than working on just the summary judgment issues. So,
are you challenging on appeal anything that would give rise to the conditional appellate fees?
Yes, we are, because we are not challenged. The conditional appellate fees were awarded only with respect to the summary judgment, and we haven't challenged the summary judgment. So I don't think those fees are
in play.
Yeah, I agree with that.
I know you're out of time, but I do want to ask you one question. Mr. Sood will give you additional time. Do you agree that Mr. Clack was entitled to attorney's fees because he successfully defended the declaratory judgment action that was advanced by Mr. Clack?
No, we don't, Your Honor, because if you look through the succession of summary judgments, the upshot of all the summary judgments was a finding that the foreclosure was void on technical grounds. That is merely the first element of a claim for wrongful foreclosure, which is a claim which Mr. Clack presented to the trial court. He got evidence of the first element, or he got a ruling on the first element of a claim for wrongful foreclosure but not on any of the other elements of the claim for
Right, that's for
foreclosure.
his affirmative claim, but he did successfully defend the declaratory judgment action that Mr. Swanson was seeking to declare his foreclosure valid.
Right,
He
Mr.
did.
Swanson wasn't seeking a wrongful foreclosure, he was seeking a declaration that his foreclosure was proper, right?
Yes, that's correct.
And he lost on that point.
He lost on that.
And so why is Mr. Clack not entitled to his attorney's fees under the Declaratory Judgment Act?
Because it's basically a stalking horse for his claim for wrongful foreclosure, which he did not prevail on for various reasons. Number one, presented no evidence of damages. We didn't have all the proper parties that would need to be there in order for him to prevail on a wrongful foreclosure claim. There was no lis pendens filed, and the buyers of the property were not there. And I would note briefly that Mr. Swanson filed his motion for summary judgment 20 months after the property had already been sold. So all of that was essentially a moot, and I don't think you should get attorney's fees for for something that provides you with no remedy and no damages whatsoever.
Any other questions? Justice Johnson?
One, just to clarify,
Sure.
is it your position that the evidence is also insufficient to support the lodestar analysis?
Yes, well, certainly with respect to appellate fees it was,
Okay.
but I don't think they're in play.
Okay.
So,
But for the fees below,
he did testify, Mr. Jaffe did testify to a rate, and he testified to hours, so I think the lodestar analysis probably was there. We just disagree that the number of hours should have been segregated out more. Thank you.
Thank you. Thank you. Appreciate your argument. How many minutes, Margo, do we need to add to the time? 3. You have 3 additional minutes, Mr. Sue. We're now ready to hear from counsel for appellee.
Good afternoon. I proceed. Basically, addressing the issues it looks like this panel is interested in. I want to start with the issue about valuing the property. Burns is the law here, and that's what controls, and that's what we're relying on. But there is one piece of fact that I think is really important, and it's Mr. Swanson's testimony on cross, where he specifically testified that he did not disagree with the value of any of the items to which Mr. Clack testified about. And that's a little bit different than these cases that Mr. Swanson's relying on to try to get the decision reversed. In those other cases like DMZ and Wood, you don't have those situations where the opposing party is essentially agreeing under oath that the values provided by the opposing party are accurate. And so I think that kind of takes it out of this dispute that we have here.
Well, let me ask you this straight off the bat before we get into all the fair market value type cases. What do you think about the jury charge, how it's set up? Did that include a fair market value definition in the damages question number 1? Or under the Osterberg v. Peka line of cases, do we just gauge sufficiency of the evidence based on the language used here and, based on the dictionary definitions of the words used?
Probably the latter. As the court's probably aware, there are cases that say, you can use either fair market value, but if that's not available, you can use actual value to the person testifying about it. Interestingly, the Wise versus S.R. Dallas case, 2014, in that jury charge, there was an instruction that specifically asked for fair market value. It did not ask for actual value. Our jury charge didn't specify it. I think either one could be used based on the sufficiency of the evidence. And in that case, the jury verdict, in the Wise case, the jury verdict was rejected because the fair market value evidence is not provided. And this is a unique situation and kind of different from Justice and some of these other cases. This is personal property. This is not real estate, and I think that kind of changes the analysis a little bit. I mean, Justice was very specific that in that scenario involving devaluation of real property, you're looking at price paid, nearby sales, tax valuations, appraisals, and you don't have that with personal property that any of us can go to at any retail store to buy. And in this scenario, yes, Mr. Clack did testify mostly about his purchase price and the price that he, based on, he used the term research, he used the term looking at eBay or online. I don't think there was a need to qualify each item each time at trial in order to back that up, but that should be sufficient for the jury to evaluate. And again, the jury charge specifically says you can use common sense.
Counsel, back to talking about justice for a minute. The justice case says that even when the testimony is unchallenged, it must support a verdict, and conclusive or speculative statements do not. I mean, the overall thrust of justice is doesn't seem to be just limited to the particular elements at issue in that case. It really seems to say that an owner can't just say the value, you have to say more. So how would you, it does seem that Mr. Clack's testimony in this case was a bit speculative in some instances, and he didn't have, you know, necessarily receipts or appraisals to back up his value. So even considering Burns, how do you get around justice's requirement that you really do have to say a little bit more?
Well, he did provide purchase price, but he also, there are other details in terms of some items were kind of general when you're talking about kitchen items. Some were more specific when he's telling the exact model of a chainsaw or something to that effect. So you know purchase price, you know the date of conversion. He would obviously reference all these items were used. And so I think looking at those items in general, it's beyond just a random thought. There were some where he acknowledged, I don't know. And we zeroed those out in the middle of his testimony. If he couldn't do it, we zeroed it out. He wasn't able to provide any evidence. And again, I think, I don't want to repeat it too much, but I think emphasizing the fact that Mr. Swanson agreed with his valuation makes this a bit unique. He had the right to disagree. He had the right to challenge him. He had the right to say it's a different value, but instead he chose to agree with the value.
Did he agree with
it? Oh, I'm sorry. Where in the record, did he make a stipulation? Did he state that during trial? Like where was that concession
Page
made?
51 of the record, page 51 to 52.
And was it during?
So my cross-examination of Mr. Swanson, so I state to him, my question to you is specifically with respect to the values that Mr. Clack articulated regarding the items that were gone. You disagree with the value he provided on any of those items. Answer, I can't disagree. And it continues on. As a hypothetical, he talked about the king bed set, which he valued at between $1,750 and $2,000. My question to you is, do you have any basis to disagree with the value that he articulated for that? Answer, the value, no.
But you'd agree that's not quite to a judicial admission or stipulation. That's more like someone who doesn't have the burden of proof saying he just doesn't disagree, right?
Correct. It may be a little bit different than that, but I think that's something you do not have in some of the Wood case, the Waste case, and the DZM case, where there is no admission, and maybe I'm going a bit too far by saying admission, but there's no evidence coming from the opposing party in that context.
I guess the question is that even when there's no controverting evidence, that doesn't render conclusory evidence sufficient. And I think that's the crux of the matter here. Whether it was contested or not, was Mr. Clack's evidence or testimony sufficient either to establish actual value or fair market value? Assuming that justice is the standard that we have to look at, why was the testimony sufficient to support the fair market value of these items?
Well, in his testimony, he did reference that when he noticed the stuff was missing, he went to the police, he filled out a police report, and the question following that was, how did you come up with these values? He said he looked online, and from my understanding, again, with everyday items, looking online on eBay, and throughout the testimony, I would question him and say, you know, based on your research, what did you find? You know, for personal items, it seems a bit excessive to have to require such extreme testimony in terms of, well, exactly where did you research? You know, what were all the prices? Did you have comparable values? Did you go out and do a survey? And I think that's where justice in these other cases concerning real estate difference is a differentiation. When you're talking about
Counsel.
personal, sorry.
Yes. Is it your position then that we need to review the sufficiency of the evidence on each item where damages were awarded, or would you say it's an all or nothing proposition?
I think it'd be either all. I think it is okay to look at each item, but I think with the understanding that he did talk about, preface this, that he did look on eBay and he did do some research. And, you know, so many of these items, and I want to be pretty clear that our thought is we're trying to accept the jury's verdict as is. There were many items that I disagree with. I mean, for example, he testified to having a brand new propane grill that he was going to give as a gift. He just bought it a month before, $475. He put it together and it was gone, and the jury awarded him $100. There are many others that he testified about, and they zeroed him out. And so, even though we may disagree on or I may disagree in terms of what the jury decided, at the end of the day, they have the discretion to decide and use their common sense on items which I would say are personal items that basically anybody can go out to the store and get. The race car might be a little bit different, and we can talk about that.
Can you,
No, go ahead.
I wanted to address question number 3 of the jury and the argument that causation was not really presented to the jury to support the award of damages, and specifically the use of the word any in question number 3.
So, I cited to the Bank of Texas versus VR Electric case out of this court from 2008, which referenced Rule 279. And basically under 279, if a ground is not conclusively established and at least one element is submitted to and found by the jury, the parties are considered to have agreed to waive a jury trial on the elements that were not submitted and to have submitted those to the trial court for resolution. The final judgment in this case, signed by the judge, confirmed that Mr. Swanson had converted Mr. Clack's personal property. So I think that finding in of itself in Rule 279 addresses that. However, even separate from that, the jury, kind of what the panel indicated earlier, the jury's answer to the first question essentially assumed that the conversion occurred and was valuing it. Otherwise, there'd be no reason for question number 1 if question number 3 wasn't the conversion. What's the point of it? It is kind of odd. And
Seems backwards.
there was.
It was a little unusual. I mean, obviously, I'm not questioning. There's a lot of things that happen at trial, and reasons are made for why things are presented. Do you know why they were presented in that order? Question 1, then question 3 later?
I do, because I was there. It wasn't on the record.
Right.
So the reason is we wanted the exemplary damages question. If it won't get, and the issue the judge was having was, well, I want to have the predicate. I don't want to have the damages on the valuation and then the exemplary damages question. He wanted the predicate on the conversion, so that's why it was added in that way. Otherwise, the trial would have just been the damages, then the attorney's fees, and I would have not have had the exemplary damages questions. That's what occurred, but it was off the record, so it's not in the record.
Counsel, what's your best evidence that Mr. Swanson actually took the items? As we heard from Mr. Swanson's counsel, the evidence is circumstantial to the extent that no one has, the Ring doorbell cam of Mr. Swanson carrying a propane tank.
So there were several requests for admissions read to the jury at the beginning of the trial. Mm-hmm. Many of those requests for admissions, deemed admissions, essentially answers that question, including Mr. Swanson removed personal property from the house in November 2019. He still has some of the personal property that was removed. He sold or gave it away. He knows who has it. He had somebody working for him remove personal property. He disabled the video security system. He saw the race car being removed from the garage, and he knows where it was taken. he acknowledged he had, I mean, it was an admitted fact that he had no right to be on the property.
But you would agree with me that those are mostly generic statements of personal property, which may or may not include these items, except maybe for the race car.
Correct. And I think similar to Rule 279 and the way the questions were worded, there was, based on these facts, I mean, there was no dispute. I mean, based essentially on admissions, that's the evidence there. I mean, you don't have evidence of you don't have evidence of somebody saying, oh, I see him taking the mattress out of the house. And I don't think that would be necessary in this situation. Yes, there was that Ring video camera footage. He did, by the way, I do want to point out, he did state, Mr. Swanson did state that he did remove items that he called trash or garbage or boxes, nothing worthy of being documented. Those were his words that he used. And so that's kind of an issue in terms of, well, what is he valuing, or what does he consider to be trash or something of not value versus what Mr. Clack considers.
What's your response to your opponent's argument, essentially under United Scaffolding type argument? He doesn't have to forfeit a winning hand as far as the liability question goes. He doesn't have the burden of proof, and if it doesn't properly tie liability to damages, that's Mr. Clack's problem, not his. He didn't have to make an objection. Do you have a response to that?
No, I think the mere fact that the question is being answered and the jury is actually making the determination that assigning a value to specific items, making a determination that Mr. Swanson acted with malice, making a determination that he did in fact convert any items, that essentially answers the question. I go back to Rule 279, which basically you can assume that into the judgment, and then again the final judgment basically is why I think 279 would apply in that scenario.
What is your response to the argument? I heard Mr. Beverly say that Rule 279 does not apply because all the elements of conversion were there. So it wouldn't come to save the day, right, under Rule 279 that there was an omission.
Well, I think the way Mr. Beverly's phrasing it is, I think we would then have to have had a conversion question on each item. We would have had to have 50 conversion questions.
Or one question in 50 lines, right?
Possibly that would.
Or what I heard him say is have a predicate language in question number 3. In other words, did Mr. Swanson convert any of Mr. Clark's property identified in question number 1?
Correct, yes.
Okay. I guess the question is, do we need that language to make that conclusion?
No, I don't think so. I think here, with the language we have, it supports the jury verdict as is.
Can I ask you, this is a question we asked Mr. Beverly, if we find that there is legally insufficient or factually insufficient evidence as to some of the items in question number 1, the question is, if we modify the judgment, what happens with the exemplary damages? Do we equally modify the award of exemplary damage? Will we have to reverse that to the trial court? We're trying to figure out how all of these pieces are connected.
So, and my cross appeal on revaluing 2 of the items and readjusting the exemplary damages kind of addresses that somewhat. My answer is no. I think the exemplary, I mean, you have the Texas Civil and Remedies Practice Code that has a $200,000 cap.
Right.
The damages, the exemplary damages determined by the jury was $200,000. I think that's it. That you were within the cap. Now the question is this a constitutional violation under State Farm or Gore versus BMW? And I think the answer is no. There's a question about what's the ratio as one element, where we were at 3.5 to 1. If we accept the court's, the district judge's decision to drop the value, we can still keep the $200,000. We're at 3.9 to 1. But all the Texas Supreme Court said is 4 to 1 might be close to the line of impropriety, and that's all we have. And I think there's a lot of other factors to go into it, including the dollar amount. We're in the grand scheme of things, the dollar amount is not so substantial here to where 4-to-1 would be, I would say, would be unconstitutional. If it's a $50,000 verdict, damages award, and you're getting $200,000, and let's say we don't have the cap, that's a 4-to-1 ratio, but that's a little bit different than a $100 million compensatory damage award versus with a $200 million punitive damages award. So I think it looks different. And the same, you could go the other way. If I have a $10 compensatory damages award with $1,000 exemplary damages award, I would say that's not, yeah, it's 10-to-1, but that doesn't necessarily mean it's unconstitutional.
But we still have, I understand your argument, and I'm following it to say that as long as it's within the bounds of Texas Civil Practice Remedy Code 41008, then the award is not excessive. That's not really the test that we're asked to follow under the guiding principles when we're looking at excessiveness of punitives, right? So it cannot be that just as long as it falls within the cap, it is necessarily reasonable or not excessive.
Correct, and I think some other factors to look into, and I reference this, is the value of the theft. And so if he's converted over $30,000 worth of items, that could be considered a felony, and then the cap could be, I mean, well, I know it's not a cap, but that could be a factor that goes into it. And I think there are a lot of other factors. I mean, in this situation, there's no dispute that Mr. Swanson apparently disregarded orders or decisions from 2 courts. He lost the eviction case. He didn't care. He went on Mr. Clack's property, took the items. I think it was pretty clear in Mr. Joffe's testimony, as well as his time records that all came into evidence, that the beginning of December of 2019, Mr. Clack was just going to walk away. And they told his opposing attorney, all he had to do was wait 2 weeks to allow Mr. Clack to move the stuff out, and because that would be when the trial was going to take place. But instead, Mr. Swanson comes up 2 weeks early and helps himself, and then changes everything about the case, which is what.
Well, and of course, that's all evidence that would support the malice finding, right?
Correct.
But we were just trying to really understand the excessiveness argument. Mr. Beverly in the brief argued that this was really more of a economic harm. There was no physical injury, no physical harm. Mr. Clack was remunerated for all of his loss. The jury had the opportunity to basically compensate him for any of these damages. And so it's that question whether these 3 constitutional guideposts really support the award of a 3.5 punitive award.
Understood. And I think we have to look at the purposes of the exemplary damages, deterrence and retribution. And I think Mr. Swanson's actions, when taken as a whole, are pretty severe, given the fact that he has several properties, he knows how this is done. I don't look at this as a way to reward Mr. Clack. I think this is a way to punish Mr. Swanson, and I think that's one way of looking at it. I don't think it's excessive by any means.
You mentioned time records a minute ago. What is your position on whether segregation was properly preserved in the post-trial motion?
I don't think it was. My understanding, I mean, there was, again, no objections, the cross-examination of Mr. Joffe as well as myself was very limited, no opposition to the jury charge, but also Mr. Joffe did testify about the segregation. His time records were presented as is. He did testify, I've put in 300 hours into this case. We were asking for 215 hours of his time compensated based up until the summary judgment decision. We testified as to rates. I think I provided evidence of rates between $300 to $1,000. He provided evidence of between $450 to $850. Theoretically, the jury could have, again, no contrary evidence was provided. The jury could have gone with $1,000 an hour and awarded him $215,000 in attorney's fees. That would have been within the scope of the evidence presented, and it would have been reasonable. They awarded just under $100,000 instead.
So beyond the segregation of cutting it off at the summary judgment stage, I mean, presumably the conversion claim had already been advanced prior to the summary judgment stage, so there probably were some fees associated with the conversion claim. But looking at the record, there are some entries in the billing records that relate only to conversion. And so I'm trying to understand, was there any effort to actually segregate or clean out all of these billing records and to really carve out an amount that was related to conversion and set it aside.
Well, the records were extremely detailed from my review of them. I think he went in a lot of detail about each item. These are presented to the jury. The question to the jury was specifically what was amount of fees that would be appropriate for, I don't want, the term wrongful disclosure I think is kind of improper here in terms, I know that was used in the brief a lot. Contest the validity of the disputed foreclosure and prove it was defective. There was a lot of overlap between the work. And so when he's talking about 215 hours, we don't know what the jury actually decided, because they could have said, they could have gone through it and said, all right, it looks like he did 175 hours related to this. Let's use this dollar amount, and that's how they got to it. We don't know. I mean, because again, they could have gone anywhere from $300 some an hour up to $1,000 an hour, because that was the evidence presented and there's nothing contrary to it.
Real quickly, do you believe that the conditional appellate attorney's fees are in play, and if so, why?
I do not, because he's not challenging the summary judgment decision, so I don't think that there's, we're not seeking any, as long as that's the case, we're not seeking conditional appellate fees.
Any further questions from the panel?
Thank you.
Thank you so much. Mr. Beverly?
Thank you, Your Honor. First point I would like to point out with respect to the justice decision, this court has basically adopted that for personal property in the Mathis v. Mathis case, which I have the site here for somewhere, but I believe it's also cited in our brief. With respect to the deemed admissions, very clear that at the trial, mostly on cross-examination from Mr. Clack's attorney, those deemed admissions went away. Mr. Swanson, on cross-examination, he didn't take the race car. There was no car on the lot. He did not have any of Mr. Clack's personal property. The only items he removed were garbage and nothing of value. Some of the stuff he put on the curb was removed by Mr. Clack himself. Most of the items in the garage were removed by Mr. Clack, and he specifically denied taking many of the items that were.
But wouldn't that just remove the deemed admissions from the universe of the jury absolutely has to take them as true to the jury can decide which to believe, the admissions or the trial testimony? I
think the deemed admissions go away once, and that is the Marshall v. Weiss case, 767-699 out of Texas, Supreme Court in '89. I think they go away at that point.
Does there need to be a request to the trial court to make that clear to the jury?
That would be the best practice, I would say. I can't argue with that. Marshall's been cited over 61 times, basically, for that proposition, including a couple of times by this court and the USAA County Mutual v. Cook, 241 Southwest 3rd 93, and a non-properties v. Affordable Power, an unreported decision. So I did want to talk about exemplary damages a bit, because I had quite a few questions about that. The degree of reprehensibility is the critical factor on exemplary damages. That's from the Texas Supreme Court, that's from the United States Supreme Court. And when you look at the 5 factors, as we've explained in our brief, none of them are there, I don't think. Harm was economic, not physical. Only evidence is that Mr. Swanson believed that the property was abandoned. There was no evidence of any kind of careless disregard for Mr. Clack's health or safety. No evidence that he was taking advantage of a financial vulnerability of Mr. Clack. And as far as his culpability, like I said, he testified the property was abandoned. He had reasonable belief to believe that, having the utilities turned off, talking to the neighbors. So I think, ultimately this was a kind of a real estate deal that's gone bad. And I don't think it's the kind of case that's appropriate for exemplary damages. And we would ask the court to reverse and render judgment that exemplary damages are not appropriate in this case, along with the other remedies we've asked for. Thank you, Your Honor.
Any further questions?
All right.
Thank you both sides for your argument and your briefing. This case is submitted and we are now adjourned.
All rise.